SJC number 12195, the Guardianship of K.N.
Good morning, Ms. Bilchin.
Good morning, Your Honors. May it please the Court, Claudia Bolgan for the appellant child. Your Honors, this case asks this Court to rule that an indigent guardian who qualifies as a de facto parent should have the procedural due process right to appointed counsel in a removal proceeding. The first issue to address
Sorry,
is
in a removal proceeding where the mother or parent is entitled to counsel, or in every removal proceeding?
the removal proceeding at issue here is brought by the mother, and the mother has counsel.
Right, but are you limiting it in the same way that we did to the mother, that it's only where there is a colorable claim by the mother that would trigger the right? Or are you saying whenever there is any guardianship, even if the mother's not entitled to counsel, that the guardian would be?
Yes, Your Honor, I'm limiting it to when a parent has the right to appointed counsel, or even if the parent doesn't exercise her right to appointed counsel, say has retained counsel, the triggering event in this case, and the reason why this situation is so unfair, is that the guardian is the only one in this removal proceeding without the right to appointed counsel.
Can we start at the beginning here? The guardian is not the party here asking for a lawyer. It's the child.
That's right.
That's a problem.
This is not a procedurally perfect case. The guardian did request counsel at the trial level and did attempt to appeal, but that appeal was dismissed for procedural error. Then after that,
So the question in this case is then not the guardian's right, but the threshold question is whether the child has the right to press the guardian's right, such as it is, to an attorney, right?
right, the standing issue, though, should not hold this court up from deciding this very important point for three main reasons. Number one, the child's best interests in these proceedings is the touchstone. The child is coming here and saying, it is in my interest to have the guardian have appointed counsel. Why? Because it will be more likely that the relevant information gets before the probate court judge, and then the decision will be in the child's best interest.
Is
So
that substantively, is that your last argument? I mean, in other words, your last argument seemed to be, if you don't buy that there's a due process, putting the standing apart, if you don't buy that there's a due process right on the part of the guardian, at least the best interest of the child could trigger the need for counsel for the guardian.
that is part of that argument, and that is also part of the de facto parent argument, because in any proceeding with regard to the welfare of a child, it has to be in the child's best interests. And recognizing the guardian's de facto parent rights and appointing her counsel with respect to that is in the child's interest with respect to standing, and also with respect to a potential equity argument if this court decides to go that route.
Have we decided a case where a de facto parent has a liberty interest in the relationship with the child?
No, Your Honor. There is a vacuum in this court's jurisprudence on the issue of de facto parentage. There are cases that discuss how that status is attained, and best interest of the child is very important in how that status is allowed in the first place, which is why I say to Justice Botsford's question, best interest is the overriding feature here.
How would you have us define de facto parent?
With respect to the cases, that it's relatively clear what this court uses to define de facto parentage. Some period of time living with the child, whether there's a 2-year requirement or not, might be an open question. But the person lives with the child, cares for the child, is the primary caretaker more than 50% of the child, does so without the expectation or primarily motivated by financial compensation. And essentially, this a relationship has come about either with the agreement of the legal parent or because the legal parent is unable to provide these functions for the child. So that is pretty clear in this court's jurisprudence when a relationship comes about. What isn't clear is after that status has come about, then what? Then what rights does a de facto parent have going forward with that status? And what this case brings to bear is that at the very least, this status confers some procedural due process protections. There's recently suggesting, the case law that recently suggests that maybe de facto parentage doesn't have all the rights and privileges of legal parents for substantive due process reasons. And that's fine because this is not a substantive due process case. This is a procedural due process case. What
But
procedural?
you need a substantive right for the procedural due process to get triggered, don't you?
That's not what the Supreme Court seems to suggest. The Smith versus Offer case suggests that there are fundamental rights that trigger substantive due process protections. And then there are liberty interests that may not be fundamental, that trigger procedural due process protections. And that's the distinction that this case brings up.
Is this something we should leave in the hands of the judge?
I'm sorry,
The discretion whether to appoint a lawyer?
that might be acceptable if there was no liberty interest to protect. So my first argument is that there's a liberty interest to protect.
If we don't find a liberty interest, it could be something that's in the discretion of the judge, correct?
And the reason that that's my second argument, Your Honor, is because currently judges don't think they have even that discretion, that there's no statutory or other right to counsel
And
for a
that's what
guardian.
you're asking us to obviously.
Yes, exactly. But the issue with that is that now it's a case-by-case basis. And, in the real world of the probate court, that essentially means that some de facto parent guardians will get counsel and some won't. And there's inherent unfairness in that as well. So I'm asking for a right to counsel, not a right to ask that the judge exercise his discretion to appoint counsel. Although if that's what this court decides, that's more than a guardian has right now, which is why I asked for that as an alternative.
But just to stress the point, you're saying that the guardian has a due process right separate and distinct from the best interest of the child.
That's correct, but it furthers the
And
best interest of the
It's a
child.
liberty interest? that the
It's
gal-
yes, Your Honor. There has to be a liberty interest to trigger
Right,
procedural
that's
due
what
process.
that's what I was trying to say, but I
And-
didn't say it as well as you did. So, and the liberty interest is,
In the parent-like relationship, in the 11 years of care, and the relationship that the child and the guardian share that is the closest akin to a parental relationship, very, very close to a parental relationship. And just because there's not a biological relationship, that the guardian isn't the actual mother, doesn't mean that the Constitution doesn't protect that parent-like relationship, at least with regard to some procedural due process protections.
Help me to understand this liberty interest. Am I correct that at a guardianship hearing, if it turns out that the parent is fit, the parent will get the child back?
Exactly, and that's substantive. And this is not a case of trying to denigrate the legal parent's rights. The issue here is simply procedural. It's in the child's best interest to have all of the relevant information in
That's why I'm
front of the
trying to
probate
sort
court
out
judge.
child best interest from the liberty interest, because it seems that the liberty interest in a de facto parent, assuming that it is the most wonderful relationship in the world, is one which will end as a de facto parent if the parent is deemed fit.
Correct.
So it is a conditional liberty interest. That is, that I am your de facto parent unless your parent is fit.
Well, let me back up from that. A de facto parent relationship can continue even if a parent is fit.
Right, but that's not the issue with regard to the guardianship.
The issue with regard to the guardianship here is whether certainly the issue of who gets custody is the ultimate issue in a guardianship removal proceeding, but that's not at issue here. The only thing at issue here is the procedural right of a de facto parent to have an attorney to present the evidence of unfitness if indeed she has the burden to do so, which it appears under the case law, even though it's quite uncertain, that she does. And that's the problem. The one unrepresented party here.
Well, what the child is represented, what's going to be missing from the presentation if the child is represented and the child can represent whatever it is that's in her best interest?
Let me answer that with 2 child-centered answers and 2 guardian-centered answers. It's always going to be in the child's best interest to have more information rather than less. But if the child is the only one with a lawyer on the side of staying with the guardian, what's really going to happen, Your Honor, is you're saying, well, child, even though you're the child in this proceeding, you're, practically speaking, going to carry the burden of proving your own mother unfit. And how can that be in the child's best interests? So those are the 2 child-centered reasons. The 2 guardian-centered reasons is that this situation puts the counsel for the child in a very, very bad position because the guardian is not the one she represents, but yet the guardian is the only adult in this situation. So that guardian is going to be requesting, should I testify? Should I file this piece of paper? Should I not? And the child's counsel doesn't represent the guardian. So with respect to that, that's a problem. And then with respect to perhaps giving counsel to a guardian only when the child is opposed to the guardian, now we're making the rights of an adult dependent on a child's decision-making. What if a 13-year-old gets mad at the guardian because the guardian took the Nintendo away and says right before trial, well, I'm going to change my position? And so now you have a child's counsel that's all of a sudden contrary to the guardian and a guardian facing trial with no lawyer.
So is the liberty interest that you're describing the interest of a de facto parent in ensuring that the child is not in the custody of an unfit parent?
The liberty interest is in the actual parent-child relationship. And to the extent that liberty interest is child-centered, absolutely. To the extent that that liberty interest is guardianship-centered, does the guardian does the guardian have the right in the relationship to try to protect the child from whatever risks and whatever potential harm may befall the child, including return of custody to an unfit parent?
And this liberty interest exists, I take it. It's not a case-by-case determination in terms of, I mean, here's my question. Is every guardian a de facto parent?
No, Your Honor. Every guardian is not.
You have to adjudicate whether X-guardian qualifies as a de facto parent?
That would be necessary, but that's similar to the burdens that this court placed on mothers in LB. In order to get counsel for a meritorious removal proceeding, the pro se mother first has to come to court and show a meritorious claim.
But that's
and
a little
so
different than proving you're a worthy, I mean, that you've got a de facto, I mean, that's a much more complicated proposition.
Well, it may be or it may not be, because the criteria for what is a de facto parent, at least what can be a meritorious claim for a de facto parent, is durational, and it is who took more care of this child than anyone else, which in long-term guardianships where grandma is taking care of the child is not going to be a very difficult proposition to meet. So it can actually be perhaps as simple as what this court suggested in LB, a series of, a form with a series of checkboxes. I've cared for this child for more than 2 years. I've done more than 50% of the caretaking. I'm doing so without financial compensation or not for financial
Why
compensation
doesn't that all
primarily.
go back to Justice Gaziano's point that the judge should decide on a case-by-case basis of whether or not there is this liberty interest in the de facto parent?
Well, to some extent, it's the same as deciding meritorious claim. So there is some decision-making on a case-by-case basis. Not all guardians are de facto parents. So the issue is, does this court say de facto parent guardians have a liberty interest, and if, judge, you find this guardian is a de facto parent, then counsel is warranted. So to some extent, it's case by case, but there's this overriding principle, and that's what I'm advocating for on behalf of the child and the guardian in this case, that it is not just case by case if a judge feels like it or not. There's some objective criteria. You are a de facto parent guardian. You have a liberty interest. There's a removal proceeding. The mom has counsel. I'm probably going to put the burden of proof on you. Therefore, you get a lawyer.
Okay, thank you.
Thank you very much.
Ms. Kirchway, good morning.
Morning. May it please the court? Deborah Kirchway for the appellee mother. A theme in your questions I noticed this morning is, should we just leave it to the judge's discretion? And I would answer no. I mean, I think that what child is asking you to do here is to take the extraordinary step of creating this completely new category of litigants out of two existing categories to confer upon these litigants an unprecedented liberty interest that conflicts with that of the long-established liberty interests that parents and children have, and to arm those litigants with state-paid counsel.
So you're saying that a judge does not even have the discretion to do it if the judge chooses to do that now?
Well, I would say if the judge were to find such a liberty interest, arguably, they would probably have the authority to do that. But I would ask that you expressly find that de facto parents or guardians or combinations thereof do not have a liberty interest in the relationship with the child while there is a parent in the picture.
So that would be foreclosing the judge from making a discretionary determination to appoint counsel.
I would recommend, yes, that there would be.
So if they have it now, you say we should foreclose it?
Excuse me?
If judges believe that they have that discretion now, we should basically take this opportunity to foreclose it.
I do not believe that when there is a parent challenging, seeking the return of their child, and there has been no finding of unfitness, that parent should not be up against state-paid attorneys.
Even though she has an attorney.
Even though she has an attorney.
State-paid attorney.
Because that Smith v. Offer case, the U.S. Supreme Court has made it very clear that to the extent that there may be, you may want to find some kind of liberty interest because there is, we all must concede there certainly is a relationship between a de facto parent / guardian, as my sister has defined it, and the child. But Smith v. Offer makes it very clear that the parent's liberty interest comes first.
Can I just ask you before we get too far in? I understand why the parent doesn't want to have the guardian to have counsel, but why do you have standing to say one way or the other?
Why do I have?
Why does the parent get to weigh in on why the guardian should or should not have counsel?
Well, I would argue that the child didn't have standing to make this case in the first place, and obviously that's in the brief. But to the extent that the child has any right to argue it, then certainly the parent has any equal opportunity to weigh in.
So what is this interest? I mean, put aside the facts of this case, okay? Rather typical case, grandmother taking care of child because the mother is either very young or has opiate abuse or other issues that she cannot be an appropriate parent. The grandmother really has been, for all practical purposes, the mother for the child for many, many years. And now the mother says, I want the child back. Your view is grandmother has no interest in how that proceeding turns out?
Well, my view is there's a difference between an interest in the abstract and a protected liberty interest. And I would argue that certainly she has an interest, but does she have a protected liberty interest vis-a-vis a parent who has a well-established liberty interest in that relationship? I would say no.
But the parent's liberty interest derives simply because of biology.
Well, the parents...
Either the father gave the sperm or the mother gave the birth. But the person who is, for all practical purposes, the mother here can be the grandmother.
The legal parent in a guardianship case is the parent, in this case, the mother, is the legal parent. And Smith v. Offer makes it very clear that when you have a legal parent, first of all, remember that when a legal parent, when there's been no finding of unfitness, as there has been here, no finding of unfitness, a legal parent is presumed to act in the best interest of the child. Parents enter into guardianships for a variety of reasons. In this case, a very young parent, okay? No findings of unfitness. Parent is presumed to act in the best interest of the child. So the parent is doing her job as a parent to do what's best for her child. And when she comes back and says, I'm ready, I'm an adult, I'm ready to take care of my child, then there should be no extra burden, no state-armed parties who, no parties who are armed with state-paid attorneys to fight against her right to custody of her child.
The grandmother should then have sought to have the mother declared unfit.
If the grandmother certainly had the opportunity to seek to adopt. And yes, that would have she had that opportunity.
You want to push the grandmother to that length to avoid the situation that we have here, which is presumably a family relationship. I mean,
Well,
the mother and the daughter and the granddaughter are doing things together, presumably.
right. And if the mother is ready to have the child back, there should be no state-funded impediments
But that's
to
what
her
the
getting the
hearing,
child back.
but that's what the hearing's for, to
That-
find out if the mother's ready to have the child back. And I don't understand why there's not some equitable right for the probate and family court judge to look at this unique situation and see whether or not, in the interest of the child, if not no other reason, that the guardian should have counsel.
Well, if you let me address some of the, if I may, some of the issues that would lead to such an equitable decision, and suggest that if you were to go that route and say leave it to the trial judge's discretion, it's going to spawn massive litigation, and that's what I think is a problem. So in terms of one of the issues that Child has raised is that, well, it's in the child's best interest to ensure that the court has all the information. Well, that's true, but the probate court is very skilled at working with pro se litigants, very used to working with pro se litigants, and does it all the time.
Just take this case. If I, obviously you know the facts much better than I do, but this is a child who has significant health and behavioral and developmental issues to contend with. I'm going to assume that there's a fair amount of medical evidence. There may be some psychological evidence, I don't know. How is the guardian to deal with that without counsel to assist?
Well, bear in mind that, again, the child here has counsel, and that protects the child's interests. The child's counsel is going to gather all the information that is needed and present it to the judge. The child and the guardian, in this case, are aligned. Their positions are completely aligned.
That may not be the case.
In this case, it is the case. In other, I'm not sure whether we're talking about this case or other cases, but
Well, I mean, I'm positing a case in which there's a child who presents with a lot of issues that are technical or, complicated, that it's going to be hard for the guardian to put this is sort of Ms. Bolgan's point, to put the information in a form that a judge is going to find helpful without some legal assistance. But it's very critical information from the perspective of figuring out what is the best interest of the child.
well, first of all, in this case, where the guardian and the child's positions are aligned, to assume that counsel for guardian will act in the child's best interest is invalid. The guardian's attorney, obviously, that person's duty is to act in the interest of the guardian. So
Well, the issue
That's
in the
an-
case is going to be the best interests of the child. So to whatever extent the guardian's attorney is misdirecting the court, that's not going to fly.
Well, and there's, what, the thing is here, there is no evidence that this guardian can't have a fair trial without state-paid counsel. It's premature to assume that
But
that's the case.
you would agree, right, that the mother, would you say the same about the mother? No evidence that the mother cannot have a fair trial without state-paid counsel? But we found that the mother needs state-paid
Well,
counsel.
yes, and I
You think that was a mistake?
do, actually. Yeah, I think in a private, proceeding where the state is not involved, that it was a mistake. But it is what it is. Now,
Even the liberty interest of the mom?
well, in any case,
Moving on.
I want to just, I guess, clarify that the liberty interests, even if you are going to find that there's a liberty interest, then you get to the balancing test, okay? And obviously the guardian's liberty interest is going to be much less than that of the
I think
parent.
that's what we started with. If one size doesn't fit all, why don't we leave this to our talented probate judges to figure this out?
Well, let me suggest this. I believe this vital determination should actually be left to the legislature. Right now, there's insufficient information in front of this court about the practical and the financial implications of any additional right to counsel.
What do we
If
make
you-
of the Attorney General's position?
Well, that's one position. But the decision to expend additional funds is left to the legislature. And to add to by comparison,
Sorry,
the child.
I mean, if there's a right to counsel, do we say there's a right to counsel, but we're not going to declare it?
I'm
Going to wait for the
hoping.
legislature to declare what the rights are?
I advocate that you do not find that there is a right to counsel.
So, but if there is a right to counsel, you agree, we can't leave it to the legislature. That's what a right means.
If you find that there is a protected liberty interest and that a right to counsel is necessary, then you don't have to leave it for the legislature.
If there is a protected liberty interest, is it your position that the right to counsel is a separate question, or?
Yes, absolutely.
So
Say if
you're contesting two questions. One, no liberty interest from your
Correct.
perspective. Two, even if there is no right to counsel. Is that
Right. Okay, so on the first one, no liberty interest, I would say in de facto parents in general, I would argue, yes, if there's no parent in the picture, give them a liberty interest. They're the ones who have this relationship, and there's no one for it to conflict with, okay? But if there's a parent in the picture, the de facto parents should not have a protected liberty interest. So if you do find that there is some protected liberty interest, it is necessarily less than that of a parent. And so that's the factor one, the private interests. The child's interests are already well protected by the right to counsel, by the opportunity for a guardian ad litem, and also under existing de facto parent law. All of those already protect the child's interests. And now on the second factor of the balancing process, as I mentioned, there's no evidence here that this guardian can't get a fair trial. And in terms of the state's interest, circling back to where I was before, the child cites some numbers of what she feels the numbers might be in this case. I spoke to the Deputy Chief Counsel of Children and Family Law for CPCS on Friday, 4 days ago. He said there are already counties where the demand for appointed counsel in care and protection cases outstrips the supply. And it wouldn't take much for us to get to the point.
Did he know that you were coming here
He
to
did.
argue against that position?
Yes, he did. Yes.
So this is somebody authorized to speak on behalf of CPCS?
Excuse me?
This is someone authorized to speak on behalf of CPCS?
I believe so, Your Honor. He's the Deputy Chief Counsel.
This is Mr. Bennett, this is who?
Mike DeCita.
Mr. DeCita, okay.
Yes, he said that there are currently counties where there have been dozens of cases this year where the parents who have the fundamental liberty interest, their rights have gone delayed 72-hour hearings that they're entitled to
Right.
have not been held on a timely basis because of a lack of counsel. So granting a new liberty interest to a new category of people is going to undermine the liberty interests that already exist for parents and children. And I would urge you to think long and hard on this case before making a decision adverse to the child. Thank you.
Thank you.
Court, all rise. Hear ye, hear ye, hear ye. All persons having anything further to do before the Honorable, the Justices of the Supreme Judicial Court, now sitting at Lawrence, within and for the Commonwealth, at present depart. The sitting of this court is now adjourned. God save the Commonwealth of Massachusetts.